Good morning.
Good morning, everybody. Welcome to WGL AM. It is Monday, April 6th. Here we go again. Will it be a big nothing burger? I don't know. We'll find out in just a minute. We are joined, of course, by our wonderful co-host, Miss Hannah Hill from
Good morning.
NAGR. Good morning, Hannah.
How you doing?
I'm doing well. Having a great hair day again, too, Hannah. I want
I
you to
got
know
it
that.
cut this weekend. I'm much happier now.
Looks like $1 million. And then, of course, Kostas Moros from Second Amendment Foundation. Good morning, Kostas. How are you?
Good morning, guys.
All right.
We're about to see what kind of morning it is.
Yeah, we're going to find out here in a second. We had a conference on Thursday, April 2nd. They took Friday off for Good Friday. We have our 5 cases that we have been normally following. We used to call them, as you all know, the group of 5, but we are now changing the name to the group of 6 because joining the club today is the matter of Schoenthal v. Raoul. That is a challenge to Illinois' sensitive place law, specifically as it relates to public transportation. Terrible ruling out of the 7th Circuit. That comes on for conference today as well. So we're going to be carefully watching those 6 cases as we wait. And we don't have the orders list yet, guys. There it is. All right. So orders list is out. This is where we start doing the word search. Everyone starts waiting on bated breath. Hannah
No
and
Lamont.
Kostas, no Lamont. Okay,
No
so
Duncan.
Jesus.
No Gators guns.
Schoenthal denied.
Oh man.
Schoenthal denied.
Yeah.
That is a stinger. That's
Yeah,
a
that
stinger
sucks.
there.
And this was its first conference, right? Because with all the back and forth rescheduling and everything, they've never actually
Yeah.
got to the conference until
Okay,
first
so we're going to
conference.
have to talk about that one. That's
Yeah.
actually disappointing
That
news.
really blows, and that's not a good sign for Wolford either. Not that we're going to lose Wolford, but maybe it's not going to be as
Broad of an
as
opinion
we'd
as we
like
had
it,
hoped.
yeah.
Yeah.
I mean,
okay.
who knows? That could be wrong. Sometimes they just aren't consistent on that, but we'll see.
Anyone search out Vera Montez?
Let me
That's
do that.
it's not there.
Yeah.
Not there. So it looks like we're going from group of 5 to group of 6 back down to group of 5 right away, huh?
Yeah.
I'm
So-
not seeing any of the 5 on here.
So for those of you tuning in right now, all 370 of you, thank you very much. And I appreciate all of you jumping in and tell us where you're all checking in from. It appears that Schoenthal v. Raoul, a terrible ruling out of the 7th Circuit that relates to sensitive places, public transportation, where essentially the 7th Circuit said, well, if it's a crowded place, we can disarm people there. Terrible ruling. And apparently that has, in fact, been rejected by the United States Supreme Court. That will head back down to the 7th Circuit with that ruling out of there being the final ruling on that issue. So
Was
our
that
group
a
of 5,
final judgment or preliminary? I know it's our case, so I should know, but
I thought it was on final judgment. Do you
yeah,
think
it might have been. I forget. Yeah, that blows.
It does blow. It does
Yeah.
blow. So again, for you just tuning in, especially if you're from Illinois, 1, thank you very much. 2, God bless you. I don't know how you live out there, but hey, Schoenthal v. Raoul, unfortunately, has been denied by the United States Supreme Court. Can one of you guys take a look and see if this case is on there? It's Beard with an I in the middle. This is a 922 G1 case that's had more than one conference already, which is odd.
It's not there.
It's not there. So that case is going to kick on. That case has some interesting issues. And I don't know if it's issue number 2 here, the federal sentencing guideline issue that might be holding that one up, since so many of the other 922 G1 cases have kind of come and gone relatively quickly. Okay. Well, we got a nothing burger again, guys. This is getting frustrating.
But there's some good news, a little bit.
What's that,
And
Hannah?
They
Give me
don't
some
have
good news.
they don't have a conference this Friday.
Yeah, I know. We're going to talk about that. The next conference is going to be on a day that I am flying to Tennessee. Now, I might be able to do it from the studio here and still get to the airport on time. So we're gonna work out the bugs on that one. I don't trust airport Wi-Fi to do it correctly. Let's move on to the morning scramble here since we got a big bunch of nothing burgers. For those of you jumping in, just want you to know that Duncan v. Bonta, no mention of it, so it's going to get relisted. Same with Gators Customs Guns versus State of Washington. Both of those are magazine ban challenges, one out of California, one out of Washington. NAGR v. Lamont and Grant v. Higgins are challenges to Connecticut's assault weapon ban. Neither of those cases have been listed. Viramontes v. Cook County, a challenge to Illinois, technically Cook County, Illinois, assault weapon ban. That has also been relisted. And then the bad news today is that Schoenthal v. Raul, it was fun to know you, but you have in fact been denied. Here's one of the things I want to talk about coming up on that April 17th conference, which would give us a next WGL on April 20th. Kostas, you see that Gardner v. Maryland comes up on that conference?
Yep.
That's going to be interesting. That's going to be really, really interesting. I'll tell you another case that's coming up on that conference. I think this is an SAF case. This is a challenge to the NFA. This is Peterson versus the United States. Is that?
No, it's not. We did an amicus brief on it.
You did an amicus on it.
Yeah.
Okay. Well, that's a really fascinating issue because it not only generally attacks the NFA, but then it also specifically goes after suppressors within that legislative scheme. Kostas, what angle did SAF take on that when you guys came in on amicus?
We argued, I think we filed it a week or two ago, but we argued that that they should grant the case because it allows them to answer three different questions. What is an arm based on suppressors? Why registration of each individual gun is not okay as opposed to licensing. And it's not that we're okay with licensing, but it's just we're trying to pick our battles. And there's actually a great Kavanaugh dissent in Heller 2 in DC where he basically bashed registration. He said licensing's okay, but registration isn't. And so we use that angle against the NFA. And finally, taxation of arms, because this Mr. Peterson, whatever's happened with the tax now, Mr. Peterson was charged in part because he didn't pay the tax because it was active at the time. So to be honest, we did the amicus brief to support our friends over there. I hope they grant cert. I'm 99% sure they're not taking a suppressor case. You know, we got to take the shot. We're always going to try and help when we can, but I do not expect good news. They haven't requested a response yet, so they've scheduled it. They still might. Sometimes they'll request a response late, but if it gets to that conference date without a response requested, it's just being denied. You know, so
well, and that's a little trick you taught me, and we're going to talk about some of those cases there. Hannah, off the top of your head, is NAGR currently? And I'm not going to be critical if you don't, because I get how you have to allocate resources. Does NAGR currently have any active challenges to components of the NFA rolling right now?
We do not. No.
Okay.
That's one that we're monitoring that issue, but that is not one that our team has taken on. Partly, honestly, because of what Kostas just said. We don't really see a future for NFA challenges at this current Supreme Court. We can't even get them to take a assault weapons ban case at the moment, or a mag ban case at the moment. They're not going to find a way to legalize machine guns. You're going to have to do that legislatively. And with Peterson, was that the one? That was the one from the Fifth Circuit.
Yes, the one the Fifth Circuit originally said that suppressors aren't armed. Then DOJ kind of jumped in and said, "Well, we don't know about that," and so they kind of backed off that.
Yeah, but didn't DOJ actually switch positions on that? Didn't they say, okay, it is an arm. It is protected under the Second Amendment, so we can regulate it. We cannot outright ban it.
Yeah.
So if that's what they're going, if a response is requested and DOJ comes back with that, I don't really.
Well, I don't think they will, because what happened in the Fifth Circuit. So the Fifth Circuit revised its decision twice. There's three Peterson rulings. So the first time DOJ said, okay, well, they're either armed. I forget if they either said they're arms or that even if they're not arms, they have some degree of Second Amendment protection and you can't ban them. So what the Fifth Circuit did, it did this stupid thing where it was like, we assume without deciding that they're armed. So it didn't really resolve the issue. And then it just said, well, this is like footnote 9, you know, it's a shall issue regime. So, okay. And so then they revised it again after the en banc call to water down their ruling to allow for future as applied challenges. That's basically the only minor changes they made. So, I mean, I have a hard time. Again, we did an amicus brief. I hope I'm wrong. I drafted the brief, so I would definitely hope I'm wrong, but I just don't see them granting cert on this.
But you miss 100% of the shots.
We got to try, right? Because if we just said, if we only did briefs on cases we thought that'd be granted cert, well, they, you know, only like 5 or 6 Second Amendment cases ever have gotten cert. So you got to
Yeah.
try, right? But
Well,
Exactly.
and too, there's an element of it too. I mean, resources is always a question, but honestly, some of this is kind of sowing for a future harvest. The more seriously you take the various issues,
Yeah.
the more I think that you are building a case that the Supreme Court may eventually take a lot more seriously in time. So
Right.
it's not, you know, we didn't really in the resource allocation question, we didn't really decide to do it, but it's not a wasted effort and it's not wasted resources to do it.
I agree. I agree completely. Here's another interesting case that we're going to need to start keeping our eyes on. It's called Johnson v. New York. Now, the procedural history on this one's a little interesting because Letitia James tried to go ahead and waive response, and it was set for conference, and it looked like not real good. But then a response was requested on March 16th, and a motion for extension of time was filed, granted, of course, on April 2nd. This is a pretty interesting case where Johnson was denied a carry license because he could not pass the good moral cause part of what was then in existence in New York law. That, of course, was stripped out of that law by the Bruin opinion. And so now he comes back saying, hey, I got convicted of a crime because I couldn't comply with a licensing law that you found to be unconstitutional. So it's got a lot of interesting moving pieces. Whether it's going to go anywhere or not, who knows? I think sometimes the problem is that people say, I can't get a license, so they don't even bother applying. And then sometimes they get chucked out on standing because you didn't even actually try to apply for the darn thing. So a case that I think we're going to have to carefully watch. The other thing is it appears, and I checked these, Kostas, I don't know if you have any other information on it, but it appears that Paris v. SAF, NRA v. Glass, this is our young adult cases. They had a conference way back November 14th. They have not been heard from since, have not been relisted, have not had anything else done. I'm assuming those cases are being held for one of the other rulings to come down, and then we're going to get a GVR out of those.
Which is so like, how are you going to hold those but not Schoenthal? I don't. I mean, Wolford is closer to Schoenthal than Hamani is to the young adult cases. You know,
Bingo.
Like
Bingo.
I don't understand what's going on. I guess we'll see. So yeah.
Well, and then I also want to know why so many 922 G1 cases got purged, even though we had Hamani kicking around.
Yes. Me
That
too.
one's more clear to me. I think that one's just because the federal government beat its whole drum about like, oh, we're gonna have rights restoration processes ready soon. And the court's like, great, an excuse to punt, and they just left it at that.
Yeah,
you know?
That's a really good
that
theory.
restoration process that they promised us months ago, and we still haven't actually seen the rule on it.
I'm confident that is coming because they're so far along in it. But yeah, who knows when it'll actually finalize, especially now with the change up at the AG's office. So yeah, I don't know if that delays things or what.
These cases, we can do a search for it, or for those of you watching at home, you can do a search for it. This is the welcome, but don't get too comfortable. These are all cases that I found in which there had been recent petitions filed, a waiver of response, and an immediate set for conference, which Kostas has taught me that is a bad sign.
Mm-hmm.
The one that's most interesting down there is the RR versus New Jersey case, a pretty interesting case dealing with, again, kind of a proper good moral character clause in the New Jersey concealed carry licensing regime. It was brought by an attorney named Evan Napin, who actually is a really top-notch Second Amendment attorney. But I'm assuming, either of you, can you need to do a search on that one for us real quick? RR versus New Jersey. I have a feeling it probably died a miserable death today.
It did, certainly.
Yeah. Okay. Interesting issue, but one not interesting enough for the United States Supreme Court. Kostas, why I have you here, I want to ask you about, I did a video over the weekend. It came out yesterday afternoon. It has to do with Vanderstok v. Bondi. That case used to be called Garland v. Vanderstok, or Vanderstok v. Garland. It's a challenge to ATF's unfinished frames and receiver rule, went all the way to the United States Supreme Court after the Fifth Circuit had thrown the rule out. Supreme Court in the 7-2 decision says, no, they did not exceed their statutory authority. I believe Gorsuch wrote the majority opinion. So it gets remanded all the way back down to the Northern District of Texas. It's been kicking around there for the better part of a year now on these 90-day status conferences. And then Last week, we get a joint status conference that says that ATF claims is, hey, we're actually going to be rewriting that rule. So why doesn't everyone just chill out, wait until you see the new rule and see if your claims are still valid claims? In that filing, however, they said that the Second Amendment Foundation, which was an intervener plaintiff on that, was not comfortable sticking around on that holding pattern and wanted to proceed directly to summary judgment motions. Can you shed a little light on that? And I mentioned it and I said, hey, listen, I'm going to find out what's going on. I'm sure there's a good reason. I'm certainly not being critical of the procedural decisions that SAF is making there. I just kind of want you to educate the viewer on what the thought process is there.
Sure. So for those of you who remember, Vanderstok went to the Supreme Court, but it only went to the Supreme Court on the regulatory side. We also have Second Amendment claims, which is, we have the right to make arms under the Second Amendment. It's not just a regulatory definitional issue. So that said, it's been in a holding pattern for a year because we've been under the impression, and ATF now confirmed that they're going to come up with a new rule. So there's no point in proceeding with litigation until we see what that new rule is. Maybe it'll be better, maybe it'll be worse. We don't know.
Right.
But unfortunately, it's been so long now that, SAF, long and short of it is, we'd like to get on with it,
Right.
Absolutely. We can't wait forever. So, but it looks like, given the ATF and most of the other plaintiffs want to stay it, I assume it probably will be stayed, regardless of what we want.
Right.
Essentially, it seems like we're getting outvoted, basically.
Okay. All right. So there's a possibility you're going to get outvoted, and that wouldn't just jettison SAF's claims out into the own and you go proceed in it. You're going to be stuck with everyone else. And
I probably should be careful about what I say here because I'm not one of the attorneys directly working on that case, but my belief is no, we would just get stayed and wait around for,
Okay. All right.
Yeah.
All
but
right.
I could be wrong. Don't hold me to that. So.
That's right. Subject to other information from the attorneys actually handling the case. Fair?
Yeah. Yeah.
Okay. All right. Hannah, did you see that joint status conference that came out on that?
Actually did not. That one kind of flew under my radar.
Yeah. Well, it's a Rob Romano find, right? Because who's out there actually scouring joint status conferences on nothing burger cases? Rob Romano is. That's who. He's out there doing all of it. All right. I'm going to ask you guys this. Now, we've had a couple days. By the way, I really want to thank both of you for hopping on, literally unannounced, last minute, joining us last week when we got the word that Attorney General Pam Bondi was being let go. You both have had the weekend to sleep on it and talk to other people and stuff. So, Hannah, I'm going to start with you. And again, not going to hold you to it, but give me your short list. Give me 2 or 3 names on your list of people that you would just love to see be the next United States Attorney General.
Top of the list for me is still Harmeet. I want to see her build on what she started. And I think she's got the record for it. Probably a distant second would be Andrew Bailey. And then after him, I would be taking probably a pretty hard look at that Florida Attorney General. Again, I'm reluctant to elevate people who don't have actually that many years under their belt doing the job. So he would be a distant third, but he's on the short list.
Okay. So we got Harmeet Dillon, Andrew Bailey, and James, I believe it's Ulfmeyer down there in Florida. It's a good list. Kostas, where are you coming down on that?
My list is pretty much the same. I'd put Harmeet first. The only reason I hadn't mentioned her right away last week is because I thought she just wants to stick at civil rights because that seems like a more fun job in my opinion. But if she wants the top job, which I wouldn't want, if she wants it, take it by all means. Like she would be great. I'm hearing rumors today that they want to give her a promotion, but not all the way to Attorney General. And that's lame. I don't care if she's in 3rd place. Like have her, I'd almost rather have her be at civil rights or AG, but not the in-between role.
Yeah, somewhere in between where we lose her in purgatory there.
Right. Well, no, she'd still be very influential, but I want her in the top job or at civil rights. But look, if she wants the promotion that isn't quite all the way to the top, that's fine. I trust Harmeet's judgment on where she thinks she could be the most effective. As for second place, I basically have a 3 or 4-way tie with the state AGs that you just listed. I'd add Knudsen to there,
Austin Knudsen out of Montana.
Yeah, but all of them seem great, and I hate to be, they're all wonderful, but I hate to be a little mean, but they're kind of interchangeable to me. The red state AGs, just pick one of them, whatever.
A little bit of truth to that. No, there's a little bit of truth. Well,
Yeah.
I would love to be able to throw out a whole bunch of names like, oh, Bill, I hadn't even thought of that. I too kind of come down. I don't know if Andrew Bailey is as a distant second as it may be on Hannah's page, but I do think very highly of Andrew Bailey. But I just, to me, I want to judge somebody on what I've actually seen them do to issues that matter to us. And in this little channel that we do, we kind of focus exclusively on Second Amendment issues. And I'm hard pressed to find somebody who I'd be more thrilled with than Harmeet Dillon. Whether she's going to get that or not, I don't know. And I think Kostas brings up a good point. Does she want that job? Because I think we all got to admit, even if you are a big Trump supporter, come on, he cannot be an easy boss to work for.
No.
Yeah.
There's just no way. And if you take a look at how many cabinet members he's burned through between Trump 1.0 and Trump 2.0, I think that evidences that he is a difficult boss. Not saying he's a bad boss. There are good bosses that can
I'm
be.
sure by January 2029, Marco Rubio is going to be the whole cabinet. So
Probably.
If he's not the president of
I
Venezuela.
don't know. For some reason, he really likes Rubio. It's really worked out.
All right. For those of you who are tuning in, all 457 of you, good morning. I hope you have a wonderful work week. But hey, here's what you missed so far today. We got pretty much a big nothing burger. We had gone. The good news is we had actually gone from our group of 5, as Hannah labeled it, to the group of 6 because we had Schoenthal v. Raoul joining the club. But unfortunately, they had a bad day at the Supreme Court. So we're back down to the group of 5. And I'm assuming with a 2-week gap now, and they've been setting these things over to the next conference, this is probably going out to the April 17th conference. Would you guys both believe that to be the case?
Yeah, is there not a conference this week, you guys said? I hadn't been
There's
following.
not one
Not
coming
this
up
week.
this Friday.
Awesome. No
Yeah.
offense, I like seeing you guys, but I also like
I know what you're saying, Coast. This is a better way to start your work week than hanging out with us. I get it. I no offense taken.
And normally when they have one that's 2 weeks out instead of 1 week out, it takes them a few days to relist them.
Yeah, so we're not
This
going to see
week,
relist
so
right away,
we probably won't
probably.
see them today.
Well, that conference then, or the orders list on Monday, April 20th, becomes a pretty big deal because we'll have these 5 cases probably rolling over to that day. We got Gardner versus Maryland also already on that calendar, and we got the Peterson case on that calendar already. So I might have to look at shoving my flight back a little bit later in the day just so I can hang out with you guys. I don't actually have to start working until the next day. I actually am out in Murfreesboro for a couple of days before I head up to Virginia. So just so you guys know, this is the next conference schedules. Obviously, April 2, we already have done that one. It's a slightly outdated slide. So we got one coming up on April 17th, then the week after. And then it looks like we'll be real busy in May. Looks like we got a conference every Friday in May, and it looks like every Friday in June too. And we are just praying that this doesn't turn out to be another Snope, that we just get let along 15 conferences later, and it's like, oh no, we're not going to take it. And then Kavanaugh writes some like 1 page, well, maybe we'll take this in a year, you guys. I mean, sorry
John
about
Roberts and Amy Coney Barrett promised me that we'll
promise me
definitely
to
do it soon.
do it one time. Yeah.
Well,
Exactly.
just so you guys know, back in 2015 and 2016, Caetano went to 12 conferences and then got a per curiam. So
Yeah.
it's not impossible. I'm not saying you should hope for a per curiam, but that is how it would go if they were writing one.
But isn't Duncan on like its 10th or 11th already?
Yeah,
now?
I think this will be 11 or 12. I mean, and Snope went to 15, I think. So
Yep. And I think Gators is right there tagging along with Duncan. I think they've been on conference all but one time together.
Yeah, no, they have. Yeah, and the weird thing is, like, I know statistically and logically, the most likely outcome is it's being denied and somebody's writing a dissent. The trouble I have with that is what the hell is left to say in a dissent? Like, if you're Thomas, wouldn't you just say, for everything I said in Snope, like, I dissent again?
I'm assuming Thomas could have a clerk sit down with many of his old briefs, cut and paste a few paragraphs together, and we probably got ourselves a dissent.
Yeah, I don't understand why it would take this long, unless, another theory is some people have tossed around is maybe it's been voted down and somebody's writing a dissent, but Thomas or Alito or both are dragging it out in hopes of like, oh no, I'm not ready yet, and hope that we get the Third Circuit ruling, that splits with it. But that's all like I don't know. I think that's a little too gamey. I don't think that's what's going
Okay,
on.
but you bring up a good point, Hannah. I want you to think about this too. They know that this Third Circuit is out there, right? And they also know that they got some crap going on in DC with the Benson case, right?
Right.
So is this creating an additional reason beyond the normal reasons for which we put these cases in a holding pattern?
I wouldn't be a bit surprised, to tell you the truth. It's kind of changed the dynamic, and they can't be. They don't live under a rock. They can't have missed the fact that after they rejected Snope, it was open season on the Second Amendment for all of these states that started doubling down on their gun control policies. They know that's going to happen again if they say no to this group. And so when they have a yes right around the corner, if in fact one of these other cases is what they're waiting on, why would they not just buy time, as much time as possible? I'd like to think there's no politicking going on behind the scenes. I really would. But judges are politicians, I'm sorry. And watching this legislature operate, as I have been a little bit more closely these days in South Carolina, and seeing the tricks that they're up to, it's not like you suddenly become immune to that side of human nature once you put them in a judicial
Right.
room. So, and especially not in the nation's capital. There's got to be levels of politicking happening that we're not even aware of. So I wouldn't be a bit surprised if there's like multiple games being played right now.
Let me ask you guys this: is the even if the Supreme Court keeps kicking this can down the road, is there inevitably a head that's coming in the United States First District of Columbia lawsuit? Because you got DOJ suing DC on their assault weapon ban, mag ban, registration requirements. We covered the brief that Barry Arrington wrote for DOJ last week, which was, as usual, a completely kick-ass brief. But that case is coming to a head at some point, and whoever loses, that's going to appeal it.
Yeah, I mean, we'll have to see how that goes, but that unfortunately that one will be 2 years out before we get to the Supreme Court. So at least 2 years. It could be 3. I'm also curious what's going to happen with Benson. I think today they're filing their brief. Benson and the U.S. have their briefs due today, if I remember correctly.
For en banc review
to oppose en banc. So we'll have to see what happens. Again, the D.C. Court of Appeals gave us some initial good news in that they didn't already grant en banc, and they'll go through the normal process, but we'll see. That doesn't mean that they're not going to.
Right. Okay. So a lot to be stay tuned for. All right. Well, guys, thanks for being here again this morning. Any closing thoughts, Hannah? You got any closing thoughts you want to tell anyone? Tell us what NAGR's got coming up this week.
Well, we're pretty thrilled actually to have, like Kostas, to have a break, even though we are on the East Coast. Honestly, monitoring all of these, most of our cases are in the same holding pattern. I don't know if it's early yet, but I'm starting to be on Wolford watch.
Okay.
Because we've got 2 months left, and they're starting to give us the more controversial ones. Y'all noticed the Chili's case, if I pronounce that name right, came out last, the transgender counseling ban. From Colorado. That one came out last week. So it's not too early for them to start giving us the controversial ones. And depending on how controversial they get with Wolford or with Hamani, it may actually be closer than we might think. They might not hold it till the end of the term. So that is one of the things that I'm watching for.
Okay. Kostas, what are you specifically watching for?
Especially after Schoenthal's, again, maybe Schoenthal's denial is misleading, but if it's denied because Wolford's going to be a narrow ruling, then I expect Wolford in the next month. I don't think they're going to wait till June, because it's not even controversial at that point. It's it's about the vampire rule. If it's just about the vampire rule, then Hamani, I think, will probably last longer simply because it was heard a month later. So yeah.
Right. Well, I tell you, that would be so unfortunate that for the Supreme Court to have to waste bandwidth, time, and energy on that crappy law out of Hawaii and then get a ruling that couldn't be beneficial to large swaths of lawful gun owners nationwide would be really disappointing. It's a real waste of resources.
Well, it's still important that the vampire rule be killed because that
No
is
doubt about it.
it's terrible, you know.
It's
But
terrible, and Alan Beck absolutely did the right thing in taking that case up. I saw Alan's name on another case recently too. I think he's knocking heads in again out there, isn't he?
yeah, he's doing a non-resident carry. He's always doing Hawaii. Like I always joke, he should be entitled to an island when he's done with all of
Should.
Yes,
Yeah,
he
his own little private island. That'd be great. All right, listen, for all of you who tuned in this morning, thank you very much. I really do appreciate all you. You guys were all checking in. I was geeking out in the comment sections before, so we had all kinds of states. A lot of people behind enemy lines that are most interested. Virginia, I know you guys are very carefully watching this. You're going to need to become very familiar with what's going on in the United States Supreme Court. For those of you tuning in late or catching it on replay, we got a nothing burger on our 5 main cases that we've been carefully watching: Duncan, Gators, Lamont, Grant v. Higgins, and Viramontes. Schoenthal v. Raul joined the party, but they didn't last very long. They've already been excused from the party. So Schoenthal v. Raul has been rejected. We will be back tentatively scheduled right now for the morning of April 20th. And I want both of you guys to have a wonderful week. Hannah, for 2 Mondays in a row, solid hair day today. You are rocking it. I like it.
I appreciate it. I was hoping it would bring us luck, but it's nothing so far.
Yeah, well, I'll get a few gray hairs between now and next time, and then maybe we'll have a little bit of luck with that.
Next time will be the first time we have Gardner on, so we'll see if anything comes of that, I guess.
Exactly. And next Monday evening, remember, Kostas and I are back for Behind Enemy Lines, Volume 7. So tune on in. We'll have lots to talk about. We're going to talk a little bit more about that Vanderstok case. We're going to talk about some other stuff that we got. We're going to talk about the ruling that came out in Beckwith v. Frey out of the First Circuit. Pardon my language here, everyone, but a horse shit ruling. So got a video coming out on that one, but that's got some dangerous rules of law in there. You know, Second Amendment doesn't have any effect whatsoever on your ability to acquire or accumulate a firearm. Let's think what states like California could do with that kind of structure.
Yep.
So, all right. Hannah, thank you very much for joining us. Kostas, thank you very much for being here. I appreciate it. You guys have a wonderful work week. For all of you who tuned in, thank you very much. And we will see you in a couple of weeks. Have a good one.
Later, guys.
Thank you, Bill.